One of the most common mistakes I see in the divorce process with our clients is during what's called the financial disclosure process. It's a stressful time. You have to go through and gather all the information about all your assets and all your debts. And you tend to forget some of the most important items, like where you're generating your income, what's happening with your credit cards, and you forget to give us the documents. And then they don't make it onto your financial statement. And when you're in court and asked about it, it appears that you may have intentionally omitted it. Once the process is over, the court issues what's called permanent orders. And what I believe is one of the larger mistakes that our clients make is they read part of the orders, but not all of them. And it's incredibly important that each person comply with every aspect of the permanent orders issued by the court. And that's one of the big mistakes that some clients make is they don't read the entire order. They make a small error and the other party uses that against them and they're back in court, which is costing them additional fees and additional time. In the beginning of the process, there is a requirement to provide specific disclosures to the other party. And these are your financial disclosures. Each party is required to provide them to the court and to the other side. Forgetting to provide all that information to your attorney and then it doesn't get to the other side, or intentionally not providing the information, can cause significant problems going forward during the case. One of the big mistakes that I believe can be easily resolved is ensuring that you provide all your bank accounts, all your financial information to your attorney, who can decide what, if anything, shouldn't be disclosed to the other side. The statute in Colorado requires that the court look at the best interests of the children. And one element of that is for the ability of a parent to put the needs of their child before their own needs. And I find that sometimes we have parents who forget that fact and they talk about their needs before their child's needs, and that can become an issue in court. The child's needs are paramount in every case, and the best interest of the child is paramount in every case involving children. Social media can be a big problem during a divorce. Everything that you put on social media can be captured, can be copied, and can be shown to the court. Bad-mouthing the other party, bad-mouthing other people involved in the case really is a mistake that just doesn't need to happen. I advise all of my clients to avoid social media during the divorce case, as that's the best option going forward. When you're getting a divorce, the first thing that you receive is a summons and a petition, or you may be the party that initiated the petition. In that document, there's what's called an automatic temporary injunction. That means that you can't take certain actions until the court allows you to do so. You cannot cancel any type of insurance during the pendency of a divorce until the court issues the proper orders. Doing so can cause significant problems and even result in you being held in contempt of court. Another issue in a divorce is when you're in a mediation setting, understand that it's a give and take. If you walk into the mediation with your mind made up that you're not taking anything else but what you want, the mediation will fail. It's always said that if you leave a mediation feeling like you didn't get everything you want, but you're okay with the agreement, and the other side feels the same way, that's a good agreement. But if you walk into a mediation saying, I want it my way or no way, it's going to fail and it's going to end up costing you a lot more money in the end. If you have any questions about divorce or mistakes during the process in Colorado, please feel free to book a free case evaluation with our New Leaf family team.